Thank you, Chair. One of my questions has already been asked and answered, so I was just developing another question. And that's in regard to Mr. Robichaud, I think. One of the points that you wasn't able to discuss earlier, the potential for disproportionate enforcement towards Black, Indigenous, and other racialized Canadians. And of course, we know that, I don't know if there's time, if you can elaborate a bit on that. And then I'd like to know your opinion on your perspective on whether or not pardons should be granted for those who have been criminalized for simple possession.
Yes. So I'll answer the latter question first, because unquestionably, yes, if we're going to decriminalize this, stigmatizing people and criminalizing them needs to be dealt with very abruptly, and I believe that there's some talk about that once this legislation passed, and I hope it does. But that, I think, needs to be treated as a priority, because right now many Canadians are prevented from lawful employment and are stigmatized based on nothing more than something that will soon be legal. With respect to the more complicated question, and equally important, is that, yes, I do feel that this will be used disproportionately. There was an article that came out quite recently from Vice magazine that went through statistically some of the disproportionate application of charges. To use one specific statistic, in 2015, an Ontario student drug survey, 39% of people who used were white, 14% were Black. Police data from 2003 to 13, 33.8% of marijuana charges were against Black people. That's a problem, and it comes back to what I was just indicating, and that is the criminal justice system is a blunt instrument, and it's a blunt instrument that's used most disproportionately against certain groups. I'm fearful that little discretion will be employed when it comes to people who are Black, people who are Indigenous, other racialized people. I have a very serious concern about that, and we've seen this firsthand. I've seen this firsthand as a criminal defense lawyer in the application and use of provincial offenses such as the Trespass to Property Act and other acts where they're used as a step up into a broader criminal investigation and giving a lot of the sweeping powers that come from the Cannabis Act. I'm very concerned that this can be abused. And I think there is no quick solution to that, of course. It's a big problem in every aspect, but I think that's something that can't be lost upon this legislation.
Senator, Mr. Conroy is signaling that he'd like to comment. Is that okay with you?
Oh, yes.
Yes. Conroy?
In San Francisco, apparently they are doing all kinds of very progressive things to address that very issue. And in terms of funds that are going to be applied into the communities that have been most affected and so on. So, I think the government needs to look at that. Certainly in terms of the pardon question, my view is that you need to bring everybody in, not exclude them. If you want to, we know who they are, we can check out their backgrounds, we can keep a track of them. It's much easier to enforce under civil administrative rules than under the criminal law. You force them out, they're potentially competing with you in the black market. We mustn't forget that racism was the basis for the Opium Narcotic Act in 1908 in order to get rid of the Chinese people because of the opium dens and the claims for loss of profits after the riots. As Mr. Boyd has said, there was no problem with cannabis in 1923 when we added to it. But in 1972, when the charges went from 800 the previous year to 10,000, we hybridized the offenses because white middle-class kids were getting busted, and we couldn't have that going on. So there's a whole racial element to this whole thing, and if you study many of the other drugs, you'll find the same thing. So it's a very important thing in my submission that we address the problems that have been disproportionately caused to the Indigenous communities throughout Canada as a result, and that may still occur in the future based on some of the provisions in the bill.
Thank you.
Okay. Mr. Friedman has a comment on this as well, okay?
Yeah, just to build on what both Mr. Conroy and Mr. Robichaud said, one of the fundamental problems with the ticketing scheme is that it's exclusively at the discretion of the peace officer making the arrest. We know that there are almost countless police forces across this country with different policies and different ways about, doing their business. Some are better when it comes to policing racialized, minority, disadvantaged groups. Others are decidedly less so. My proposal would be that if there is going to be this ticketing mechanism, that it be mandatory, not discretionary. Otherwise, you leave it into the minds of that individual police officer. What kind of day is he having? What kind of interaction has he had with this person? Is it someone that he's dubbed a suspicious person? Is it someone that he wants to leave this record on? What's the mechanism of appeal for that? The answer is nothing. It's up to the discretion of the police officer, and we tend to know, and maybe because criminal defense lawyers are a cynical bunch, or maybe it's because of the work that we do, that discretion is ultimately abused. And we can imagine a scenario where peace officers who are policing well-off or whiter neighborhoods use that discretion every single day. But when they want to stop and frisk, or they want an excuse to get into someone's backpack or their trunk, that when a Cannabis Act charge is laid, they put away the ticket option and it goes right to the laying of an information.
Okay, I'd like to get a question in before round two. One of the most disturbing things that we've learned in this testimony today, we've heard a bit of it before, but particularly today, is that we could still be criminalizing young people out there. I mean, one of the objectives of this bill is to stop criminalizing our young people. And yet there are some circumstances, you start to lay them out in some of the comments you've made where they could end up as part of the criminal justice system. And I understand that the government is trying to come down hard on the illicit market, the older person who sells to a younger person and or gives cannabis to a younger person. They want to deal with that more harshly. 14 years seems like quite an extreme. Certainly, if we were talking, because the two gentlemen in Vancouver keep drawing the comparisons with alcohol. You know, if an older person gave a kid a rum and coke, he wouldn't be getting 14 years in jail for that, or even a bottle of whiskey. So there's absolutely no comparison in terms of the kind of penalties, as far as I can see. But here we're talking about some very severe things. So how do we? I can't imagine, for example, if a 19-year-old was sharing a weed with a friend who is 17, that 19-year-old's going to, that any court, any judge is going to sentence that person to a prison term. But how do we even this out and prevent the continuing criminalization of our youth? Okay, Mr. Friedman, then
Yeah.
Mr. Rowe. Well, we'll get the whole round of it, and then there won't be a second round at all.
I'm sure that my colleagues have very valuable contributions to make, so I'll just give one thought. And if we keep talking about this analogy with alcohol, I note that the Liquor License Act of Ontario actually provides for a specific exemption for parents to give young people under the age of 19 alcohol within a private place or a residence. That's not an offense at all. It's actually specifically mandated. So there's no reason why similar exemptions couldn't be carved out to both stop criminalizing what is really not criminal behavior and to keep youths from going to the illicit market. And I'll let my colleagues can certainly address other aspects of that question. But if we're looking at the liquor analogy, let's look at what the provinces do. And they deal with this exact question without criminalizing either the adult or the youth.
Okay, Mr. Robichaud, and then I'll go to Mr. Conroy, and Professor.
Thank you, Senator. I'll be brief because I know my colleagues have a lot to say about this. I too share the concerns, and the concerns it seems that you have as well. This legislation is setting up youth for failure, and in a very profound way, in my view. And I think that we really need to take a look at the long-term and practical effects that this is going to have upon youth. And I think we need to do everything to decriminalize for them and educate them, because what Mr. Friedman's alluding to is that there's a certain sensibility to that act that we would rather have our youth in our homes if we know they're going to drink, to be under supervision and to educate them on responsible drinking, because we all know, and certainly the statistics support this, because youth are at an all-time high in the developed world, in Canada, of usage. It's going to happen. So the question is, do we want that to happen buying their marijuana from an underground market, smoking it at a park, and then driving home? Or do we want to have parents involved in that so that we can take a responsible approach? And I think this legislation fails in that specific regard and in a broader regard that we've already discussed.
Okay, final words from Mr. Conroy and Professor Boyd.
Did you know that it's under the Tobacco Act, tobacco being our #1 killer, a parent or person, it's only an offense to supply a young person in public with tobacco. So you've got that exemption in terms of the Tobacco Act. You've got the exemption just mentioned a minute ago in terms of alcohol. And so I think those are very important. We need to remember that there's no lethal dose for cannabis. Certainly people could get sick, but there's no lethal dose. So we need to learn from those past legislation and provisions in order to do what the previous witnesses and the questioner indicated.
Yeah, I think all of us have been saying that there's too much criminalization in this bill. I think it was an attempt by the government to go down a road that would curry favor with a range of perspectives, politically left and right. And I think they overdid it with criminalization. At the same time, if this bill is to falter, if it was not to get royal assent, it seems to me that might mean that we would never get any kind of legalization of cannabis. We have to hope that the over-criminalization that is represented in this bill will be amended by further changes, by either regulation or by amendments to the Act itself.
Well, we just might do that. You never know.
This isn't the first time we've come up with a bring.
We've got 4 minutes left.